Item number 1 on today's calendar is a House Bill 5125 Sub B, an act relating to health and safety, the Reproductive Privacy Act.
Make a motion.
Senator Morgan makes a motion that House Bill 5125 Sub B be recommitted. That is seconded by Senator Dela Cruz. The clerk will unlock the machine. All those in favor of the move to recommit, vote in the green. Those against, vote in the red. If all members have cast their vote, the clerk will lock the machine. There are 10 votes in the affirmative, 27 in the negative, and the motion fails. Back on the bill, Senator Lynch Prata.
Thank you, Mr. President and members of the Senate. I rise in support of House Bill 5125 Substitute B. As this chamber is aware, this is a bill that has gotten a significant amount of attention, a significant amount of press. We have talked about it for months at a time. It's a bill that has passed the House and then came over to the Senate, where we made some relatively substantial changes. This bill is about codifying the current status quo in the state of Rhode Island. Nothing more and nothing less. This bill seeks to clarify and codify those rights which the citizens of the state of Rhode Island enjoy today. This is not an expansion. This is not a restriction. This is a codification of what we have now. This bill has been worked on. This bill has been vetted. This bill is clearly a codification of the current status quo. As I indicated, it initially passed the House of Representatives, and when it came over to the Senate, received some modifications. I will go through the modifications of those changes that we made. First and foremost, the issue was raised with respect to post-viability terminations, so-called, and the responsibilities of physicians at that time. We added language that made it clear that the physician would need to record in the patient's medical record the basis of the medical judgment for which the termination was necessary to preserve the life and health of the patient, and also made it clear that the physician would also have to comply with all other relevant requirements to physicians in 23-3-17, and that's a reference to an existing statute called the Fetal Death Registry. We also made clear that the Department of Health has the authority to oversee physicians, has the authority to institute discipline, deny a medical license, revoke a medical license, or establish any other discipline that they see fit, and also that if the Department of Health may determine that the physician has been guilty of unprofessional conduct, if it doesn't comport with the requirements within this statute, and we have added to the Department of Health regulations a reference to this particular statute number, again, to clarify the responsibilities of physicians as well as clarify the rights of the patients. I cannot stress enough that the references that are made to current statutes and the provisions that appear within this bill clarify the current state of the law. An addition was made with respect to the felony assault statute. And the addition that was made to make it clear that the assault upon a pregnant person that results in the termination of that pregnancy would be a felony assault, as long as the assaulter knew or had reason to know that the victim was pregnant. This, again, was added in conjunction with the input of several senators who had concerns about the ability for the Attorney General to prosecute a case in which a pregnant woman was assaulted and that assault resulted in the termination of the pregnancy. These provisions were established with the help of the Attorney General's office to ensure that it was something that they would be comfortable prosecuting if, in fact, this were to occur. The other major change that was made from Representative Williams' original bill had to do with consent of a termination for a minor. As you all know, we currently have provisions relative to consent for a juvenile, and Representative Williams' original bill expanded those consent provisions, allowing for either a grandparent or a sibling over the age of 25 to consent to a termination on behalf of a minor. I understand completely why Representative Williams put this expansion in her original bill. Her constituents in her district, there are many, many grandparents and other siblings that are raising children and may not have any formal guardianship or any other formal legal status with respect to that child. And I know that there are several senators in here who also face those challenges within their district. One of the things that we have maintained throughout this process is that this is a codification of the current status quo. This is not an expansion in any way. Allowing a grandparent or a sibling that has no guardianship or other legal status or legal authority to make medical decisions for a juvenile was a clear expansion, as there's no other place in our statutory structure that allows for someone without legal status to make a medical decision for a juvenile. There are several other portions within the bill that strikes long-ruled unconstitutional statutes that are currently on our books in the state of Rhode Island. These are things that either have been deemed unconstitutional for over 30 years, have been replaced by existing federal statute, have never been used in the history of the statute being on the books. Again, I cannot stress enough, this bill codifies the current status quo. It doesn't codify solely Roe versus Wade. It codifies Roe versus Wade and that case law that comes after it. It codifies what happens in the state of Rhode Island today. If this bill were to pass today and the governor were to sign this bill today, nothing would change from the time she put her pen to paper until the time she completed her signature. This is the exact same law that we have today. This bill represents so much more than everything that you have heard throughout this debate, not only over the last several months, but over the last several years when this issue, since this issue has reached the forefront, not only of our national landscape, but of our state's landscape. This bill represents more than a slogan, it represents more than a campaign promise, and it represents so much more than a negotiated measure to pass from one chamber to another. This bill means so much more than codifying Roe or than maintaining freedom of choice or preserving the status quo. This bill is this chamber and this legislature performing our responsibility to the citizens of the state of Rhode Island. It is our responsibility to protect our citizens. It is our responsibility to ensure that those laws, federal, whether they're through statute or whether they're through federal case law, are clear for our citizens. It is our job to make sure everybody is aware of their rights and of their responsibilities. It's our job to ensure that our citizens are clear, that our citizens don't need to run to a courthouse in Providence, nor do they need to run to the Supreme Court in Washington, D.C. We are not putting our citizens in the hands of a changing Supreme Court that seems to want to impart its views on us to change the status quo as it is today. This bill was forged through hard work by so many, not only in this chamber, but outside of this chamber. This bill came with a thorough understanding of how the Department of Health regulates physicians who perform terminations. This bill came with the understanding that the term viability is a medical term that should be made by physicians and not one that should be made by a divided court trying to establish an explanation for people. It came with the understanding that a woman in the midst of a pregnancy, either unwanted or wanted, needs our help. This bill, as you will see over the next probably several hours, will not receive the support of everyone in this room. This bill requires us to accept that certain people do not agree with the current state of the law. There are others in this chamber that may argue that we need to wait, that there's no need for this, that perhaps we need to institute a trigger or some other mechanism that would be necessary before this law would come into effect. They will argue most certainly that it goes beyond our current law. They will argue that we need to use caution. What I am here to tell you is that we have used caution, we have studied, we have put together every piece of information that we could find to make sure that we have done our job and we have codified the current status quo. What is important to remember is that these arguments, in my opinion, are not born out of a feeling that this law goes beyond our current status quo. These arguments are born out of a disagreement with our current state of the law. These arguments come from those that have a fundamental belief that no abortion should ever take place, regardless of the circumstances. I stand here before you in support of this bill because this bill is our law. This is the work that we did to create the status quo for our citizens to make it clear what is expected not only of physicians, but what the health care rights of the women of our state are. Mr. President, there will be amendments that will come before this body. I will urge the members to think about those amendments carefully, but to also take into consideration that these amendments are not meant in any way to make this a better bill. They're not meant in any way to more clearly codify the current status quo. They're meant to defeat the bill. This bill, as I said, is our law. It's the product of our work and what this body believes is the right thing for the citizens of the state of Rhode Island. Mr. President, I would be remiss if I didn't thank those who came before me, who have fought for this issue far longer than I have, particularly Senator Perry, Senator Sosnowski, Senator Golden, Senator Oyer. They may not have necessarily come before me, but they fought a lot harder than I have. Senator Archambault, who has worked diligently with me and every other member of this chamber on this legislation to get us to a place where we needed to be. Senator Miller, who has also been an invaluable partner in getting us to the appropriate language. With that, Mr. President, I move passage.
Senator Lynch Prata moves passage of the act. Is there a second? Seconded by Senator Miller, Senator Conley, Senator Gallo, Senator Sosnowski, Senator Nesselbush, Senator Lawson, Senator Sheehan, Senator Pearson, Senator Satchel, Senator Archambault, Senator Cano, Senator Bell, Senator McKinney, Senator Valverde, Senator Coyne, Senator Murray, Senator Golden, Senator Oyer, Senator Seveny. Senator, before we continue, Senator Chacon, would you like to be recorded and voting in the affirmative on the consent calendar?
Yes, I would, Mr. President. Thank you.
Senator Gallo also. It does not change the total or the bill Hearing no objection, so ordered. We are on the act. Senator Archambault.
Thank you, Mr. President. As someone who believes in a woman's right to choose, and I've had that position for a long time now, and who thinks it's important to codify the protections of Roe v. Wade, particularly given our current composition of the United States Supreme Court, I'm in support of the revised and what I consider substantially improved legislation. As Senator or Chairman Lynch Prata stated, the agreement that's reached and reflected in this sub B and this legislation accomplishes the goals that I've had all along, which have been to make sure that the felony provision is kept in the language with respect to a woman who's pregnant, who has harm come to that child, and also the grandparental provisions for the consent, which are now removed from the bill. But most importantly, it's the safeguards and the later term aspects of abortions with the new reporting requirements and the strict Department of Health oversight. Those are now in the bill and on the face of the bill. The chairwoman and I wanted to assure that physicians in hospitals provide appropriate documentation to the Department of Health. And I can say with certainty now that all post-viability later term abortions are reviewed. Also, it's the chair's language that is reflected in here and the collaboration of all those who worked on it, who the chair mentioned, that clarify the responsibilities of a doctor in memorializing the basis for any termination and the medical decisions commensurate therewith. That's now on the face of the bill. Those are the Department of Health regulations on the face of the bill. I want to commend the chair for her open-mindedness, collaborative effort, and I think the bill is in a position now where it should get passage. Thank you, Mr. President.
Thank you, Senator Archambault. Senator Dela Cruz.
Thank you, Mr. President. At the appropriate time, I would like to introduce an amendment.
I believe this is probably the appropriate time, Senator.
Thank you, Mr. President. The LC number is 0005118. I'm sorry, 0005118/43. I would just like to point out that as my colleague Senator Lynch Prata, she stated that the amendments we are going to propose are not meant to make the bill better, but in order to defeat the bill. And I do take issue with that because I know, living in a blue state, that it's almost impossible to get this bill to die. The reason for my amendments explicitly is to make this bill better in order to protect the mother and the child when possible. I'd also like to note that if this bill were to die today, no one is losing their rights. If a woman wants an abortion today, she can get one tomorrow. She can get an abortion the day after that, and the day after that, and the day after that. Abortion rights are not going away in Rhode Island. Planned Parenthood also stated this in an article. It's not going anywhere. No one should be worried about that if that's something that they're worried about. So if we could read my amendment. Section 23-4.13-3, the use of anesthesia. For the purpose of preventing fetal pain, no physician shall perform an abortion unless the physician anesthetizes the fetus, except in the following circumstances. In the reasonable clinical judgment of the physician, the administration of anesthesia to the fetus would cause serious risk to the life of the mother. Number two, in the reasonable clinical judgment of the physician, the administration of anesthesia to the fetus would cause serious risk of substantial or irreversible impairment of a major bodily function to the mother. Number three, in the reasonable clinical judgment of the physician, the pregnancy has not yet reached 20 weeks gestation. And finally, number four, if the mother directs that anesthesia not be administered to the fetus. I wrote down my remarks. Thank you, Mr. President.
Senator, you offered the amendment, correct?
Yes.
The amendment is LC 0000518/43. Senator Lynch Prata. Is there a second? I'm sorry. Is there a second? Second by Senator Morgan. Discussion on the amendment. Senator Lynch Prata.
Thank you, Mr. President. Based upon my reading of this amendment, the indication is to use anesthesia for the fetus if the pregnancy has gone beyond 20 weeks or is at the post-viability stage or the peri-viability stage. The simple answer to that is that this is a medical judgment, and in no way do I think that this body has the right or the authority to tell a doctor when and if anesthesia should be used on a patient. I certainly didn't go to medical school, and I'm not sure if anybody else did, but I certainly wouldn't presume to substitute my medical judgment for a physician. But secondly, it's my understanding that if a termination were to occur under these circumstances, it would almost certainly be an emergency situation in which anesthesia would most definitely be used upon the mother, and because the mother and the fetus share blood, it would the anesthesia would go through to the fetus as well. Again, this is not an issue that was raised while we were working on this bill, but based upon discussions with physicians and other discussions, this was something that came up, but it's clear to me that this is solely a medical decision, and I would urge the members to vote against this amendment.
There are a number of lights lit. However, I think at this point that we should deal with the amendments that are being offered, and then anyone who would like to speak on the bill after the amendments are offered, we'll allow that. So if you're looking to speak on the bill itself now, let's address the amendments, and then we'll go from there. Senator Dela Cruz.
Thank you. Although I would have loved to brought my ideas to the table, I wasn't invited to the table. We talk a lot about that there was a negotiation, but a negotiation would mean that there were two sides at the table. No minority representation was invited. I certainly wasn't, and I sat through 13 hours of testimony. I would have gladly have submitted that as something to add to the bill. Secondly, local anesthesia. I'm not a doctor. I did speak to an anesthesiologist at the Burrville Family Fair on Saturday, and she said local anesthesia does not affect the fetus. Only certain types of anesthesia will affect the fetus, and that's what I'm trying to get this body to understand. Let me explain to you an abortion procedure if you don't know what it is. Depending on the stage, and I hate to describe it to you, but I feel that I must. With a clamp, you would reach into the uterus, find an appendage, take it, twist it, and rip it out. Think of your Thanksgiving turkey. You got that nice thick leg there. You go to pull it off, and it doesn't come off so easily, so you have to twist it and rip it out. Now, if any of you were meeting your demise and you were being done so in such a gruesome way, I assure you that you would want to have anesthesia so that you would not feel the pain of having your muscles ripped limb from limb, or having your limbs ripped from limb to limb, your muscles being ripped apart. And yet, and I'm just going to read my remarks. I think it will be better than me going off the cuff. So colleagues, my amendment will provide anesthesia to a fetus at least 20 weeks gestation. The aim of this amendment is twofold. First, to minimize the pain of the fetus that would experience during the abortion procedure. And second, I believe that this act is an act of decency and humanity and may comfort the mother in this procedure. Let me speak to the first point, minimizing the pain of the fetus. Since Roe versus Wade was decided before the invention of the ultrasound and modern 3D imaging, I'm not sure doctors understood that the fetus was capable of experiencing pain. Modern medicine tells us that as early as 8 weeks into development, the baby in the womb has begun developing pain receptors. We also know from former practitioners that babies often recoil from the abortion instruments inserted into the womb. There is no question that the baby post-viability stage of its development is feeling pain of dismemberment. Remember, according to the amendment bill before us, the baby at this late stage of abortion could exist outside the womb. I call on us as compassionate lawmakers to minimize the pain of this baby before it is aborted. Its final moments in the womb should not be unimaginable pain that comes with this procedure. Regarding my second point, my hope is that this amendment will ease the emotional toll of the women who choose to have an abortion. I'm sure that for women who choose to go forward with an abortion faced with the grueling and torturous decision, knowing that her baby is being anesthetized and is numb to the pain being inflicted will provide some comfort to her. There are thousands of women who have made this difficult decision and have had an abortion. There are many who have regretted their decision and have talked about the pain and guilt before the Senate Judiciary Committee, again, where I sat for 13 hours. I heard their testimony, women who shared the wrenching stories of the heaviness with them because they knew their babies experienced pain as they were being aborted. Friends, my amendment in no way stops abortion. Just the pain of the fetus during the abortion, and perhaps of the mother too. This year, this body submitted 18 bills aimed at protecting animals. And although these small creatures have no personhood and no voice, you have been brave enough to speak up for the humane treatment and care. Great organizations have recognized your work in this area. These awards are well-deserved, and my colleagues should be applauded. Now I ask you to extend the same care and treatment to these small creatures in the womb by passing a simple amendment that would provide anesthesia to a baby in the womb.
Thank you, Senator Dela Cruz. Senator Morgan. Senator Morgan, pass. On the amendment has been moved and seconded. The clerk will please unlock the machine. Have all members recorded their vote? The clerk will lock the machine. There were 12 votes in the affirmative, 26 in the negative, and the amendment fails. Senator Lombardi.
May I speak on the bill now, Mr. President?
You can speak on the bill, Senator.
Thank you, Mr. President. Ladies and gentlemen of the Senate, back in May, when we were debating this bill in Judiciary, actually debating the two bills in the Judiciary, I went into great detail as to why I voted no in committee, and I do not intend to go in such great detail tonight because I think that this body has heard the arguments, and I think that this body should move on to what is ultimately inevitable vote. But at the time, I voted no for two reasons, and one was that, in my opinion, and legal minds in this room, and there are some great legal minds in this room, can differ on the difference between whether this represents a codification of Roe versus Wade, whether the original bill represented a codification of Roe versus Wade and its progeny, or it didn't. And in my opinion, at that time, I believe that it went well in excess of the protections granted under Roe v. Wade and its progeny. The second reason that I cited at that time was that this was purely a contingency plan. That if in fact this is intended to codify Roe versus Wade and its progeny, it really is not an imminent concern, because the fear, as I understand it, is that a judge will die, another appointment will come to the Supreme Court, and ultimately they will overturn Roe versus Wade. And I pointed out at that point that it was not today, tomorrow, or anytime soon, notwithstanding the alarmist mentality that was pervading the area. At this point, I still intend to vote no on the bill, but I do so first with applauding both sides of this issue, of those folks on both sides of this issue that handled themselves professionally and with dignity. My chairwoman, who I disagreed with, my dear friend and roommate, Steve Archambault, who I apparently disagree with today, I have nothing but the utmost respect for the work that they did on this bill and the respect that they gave everyone, the open and obvious debate and transparent debate that took place. I do not applaud the folks that made this an us and them mentality, folks that do not wish, either within this chamber or in the gallery, or constituents who believe that those of us that disagree are evildoers, okay? And I commend everyone for professionally and vigorously vocalizing their position. But during that time, we were met with handmaidens and hangers rosary beads, and holy water. And that in and of itself gave me great pause, because I think we lost sight of what we were trying to do with this bill. I disagree with the chairwoman in one respect. I do not, at least as this person stands here, do not believe that this is because of a deep-seated predilection against abortion in general. I think that what's here is the issue of a late-term abortion in a time when Roe versus Wade and the progeny is the law of the land. I think that's the issue before us. It's not whether abortion should be legalized or not. That's been resolved in 1973 and since then for the last 47 years. So I say to you that I do not believe, again, that this bill represents a so-called codification of Roe versus Wade and its progeny, because the original problem that we had with the bill in committee, those of us, the 5 that voted against this bill, was the issue of the health of the mother. Nothing's been added to the definition of the health of the mother. What's been added, clearly, and I applaud Senator Archambault and the chairwoman and whoever else was in that mini committee that prepared this sub B, and I applaud them because clearly it's an attempt to pull back on what the original bill was. I agree with that. But what this bill does, it does 3 things, as the chairwoman stated, but the one that's relevant is the issue regarding the reporting requirements. As it relates to post-viability termination of pregnancies, the only thing that's added is the language that there must be a report placed in the medical records of the patient. Nothing is there to define the word health of the mother. So I disagree, and when people say, well, how many times has that happened? Never. Well, I disagree with the assertion that that's never happened. It certainly has happened, and it will happen, and it can happen, and that's what we need to protect here. But lastly, Roe versus Wade is still the law of the land, and what Senator De La Cruz said is still true. Anything we do tonight, nothing will change tomorrow. Roe versus Wade is still the law of the land, and it's troubling that we are here seeking to codify, and I'll be curious to see if what this body does should we vote on a trigger bill, because if the concern is that Roe versus Wade is going to get overturned, then that should be at that point. But I want to commend I'm still going to be voting no, but I commend my colleagues here and the folks up in the gallery for their professionalism in this rather heated debate. Thank you, Mr. President.
Thank you, Chairman Lombardi. Senator Archambault.
Thank you, Mr. President. I'd like to change my vote on that De La Cruz amendment to a yes. I'm thinking of other things. I pressed no. I meant to vote yes if it's not going to change the outcome.
Senator Archambault would like to change his vote from a no to the yes on the amendment, on the previous amendment. It does not change the outcome. Hearing no objections, so ordered. Senator Morgan.
Thank you, Mr. President. It is our job to protect life, all life, human life, where they cannot protect themselves. Babies need protecting along with their mother. Therefore, I am making a motion, Mr. President, to hereby move amendment LC 000518/29. And what this amendment does is it will, on page 2, line 25, by deleting the language in the medical judgment of physician and inserting in case of medical emergency. This will change, this would make it so it would, a late trimester abortion would happen only in a medical emergency. So we're saying it doesn't happen, so let's not let it happen unless it is a medical emergency. Thank you.
Senator Morgan offers LC 000518/29. Is there a second? Second by Senator De La Cruz. Discussion on the amendment. Senator Lynch Prata.
Thank you, Mr. President. I rise in opposition to this amendment. The case law is very clear that post-viability terminations are not to occur unless they're necessary to preserve the life or health of the mother, which is exactly what this bill says. To further restrict a physician's medical judgment and add, in quote, in cases of medical emergency, could not only prove harmful to the patient in the situation, it will cause the medical decision maker to hesitate. It will cause the sacrosanct relationship between doctor and patient to be interfered with by legislation, which is absolutely inappropriate, and I urge my colleagues to defeat this amendment.
Thank you, Senator Lynch Prata. We are on the amendment. Senator Morgan.
Thank you, Mr. President. Case law does not define health. This would define it, as Senator Lombardi said, it's not defining health. Undefined health, an exception would be allowed post-viability abortions to be performed for reasons of mental health, physical or emotional, as well as physical health. The scope of the health expectation needs to be defined and narrowed. Therefore, I am suggesting placing this as replacing the wording to a medical emergency, which would define health.
Thank you, Senator Morgan. Further discussion on the amendment? Hearing none. Those in favor of the amendment, please vote in the green. Those opposed to the amendment, in the red. The clerk will please unlock the machine. If all members have recorded their vote, the clerk will lock the machine. There are 12 votes in the affirmative, 26 in the negative, and the amendment fails. The act, Senator Dela Cruz.
Thank you, Mr. President. I have one more amendment, LC number 000-518/34.
Thank you. Senator Dela Cruz offers the amendment LC 000-518/34. Is there a second? Seconded by Senator Morgan. Discussion on the amendment. We'll give it a second to get up online here. Refresh. I understand it is up. Senator Dela Cruz on the amendment.
Thank you, Mr. President. So on the original bill, page 2, line 18, there's a paragraph, and it starts with prevent the Department of Health from applying to licensed healthcare facilities that provide abortions and generally applicable regulations and standards that are in accordance with evidence-based, medically recognized standards for the provision of abortion in compliance with the state and federal. It goes on and on. I wanted to simplify that language, make it concise and easily understandable. So my amendment would say, prevent the Department of Health from regulating facilities that perform abortions. So the Department of Health currently regulates, and my bill would keep that intact. Obviously, I want women to be protected and make sure that their facilities are inspected. So what I'd like to start off with is, this is a solid amendment. Whether you're pro-life or pro-choice, it is not a point, this is not the point of the amendment, being pro-life or pro-choice. This amendment is about ensuring that the clinics that provide and perform procedures are safe, clean, and abiding to the same medical standards as medical and surgery standards as hospitals and clinics doing comparable work. My hope is that the clinics performing these procedures and their proponents are not just tying this issue to women's health because it polls well. I trust that they do care about women's health and that the mantra safe, well, it used to be safe, legal, and rare, now it's just safe and legal. But I'm concerned that it will just soon be safe. So yesterday, I was speaking to a representative of the Department of Health. This is what was really concerning to me. I called the office and I said, I would like the last 10 years of the inspection reports for Planned Parenthood. She said, in 10 years, there have been 2 inspections. By law, it should be yearly. Hospitals are yearly. Walk-in clinics are yearly. Heck, restaurants are yearly. My McDonald's should not be held to a higher standard than the facilities that perform abortions, surgical procedures, and chemical procedures. This is from the Department of Health, 2 times in 10 years. Is that safe? Are we talking safe for women? I think not. These clinics, in which toxic chemicals are administered and harrowing surgeries are performed, yet there is no annual inspection conducted. This amendment attempts to secure that women that visit these clinics are able to do so knowing that the Department of Health has ensured that they meet the medical standards and guidelines in our states, and I ask you to support this amendment. I'd also like to bring to your attention that this one was in 2013, that the Honorable John Upton testified before the committee that abortion clinics are inspected yearly. As you can see, that's not the case. There's also been, just recently in the news, a Missouri Planned Parenthood in which had to be shut down because they were not adhering to the standards. We also can't forget of Kermit Gosnell. I mean, these things do happen. I'm not making this up. I'm not fairy tale stories. These are documented. It does happen. We need to protect women. They're making a difficult decision. Let's make sure it's safe.
Thank you, Senator Dela Cruz. I remind my colleagues that we are on the amendment. On the amendment, Senator Metz. On the amendment, Senator Morgan.
Thank you, Mr. President. We have documentation to prove that these clinics have only been inspected twice in the last 10 years. Is that acceptable?
Senator Lynch Prata.
Thank you, Mr. President. I rise in opposition to this amendment. This amendment is illustrative of a so-called trap amendment, or a trap statute, where the intent is to regulate facilities such that they are unable to ultimately perform abortions. These laws have been struck down already in Texas and Louisiana and are violative of Planned Parenthood versus Casey, so I urge the entire body to vote against this amendment.
Thank you, Senator Lynch Prata. Further discussion on the amendment, Senator Dela Cruz.
Thank you, Mr. President. Again, as I stated when I talked about my amendment on anesthesia, I am not trying to prevent anyone from having an abortion in this state. Just trying to make sure that women are doing so, and if they're doing so in a safe way. Just yesterday, I think, or 2 days ago, I received some pictures here. Planned Parenthood, hospital. Someone had to leave to go to women and infants because they were taken away in a stretcher. Is that going to show up on the report? Safe, legal, and rare, now to safe and legal. Now what? Legal? That's it? It's not about restricting women's rights. It's about protecting them, keeping them safe.
Thank you, Senator Dela Cruz. Senator Raptakis, we are on the amendment.
Yes, Mr. President. If my chairwoman would yield on a statement she said, I have a question regarding the amendment.
Will the floor manager yield to a question?
I'm not sure if I heard correctly, but you're saying that in Rhode Island, because I hear 2 arguments on this side and 1 argument on this side. So under state statute, do we have a law that we inspect these clinics yearly, or did you say that under, I guess, a decision that was made by the Supreme Court that we don't have to have them inspected yearly?
I actually didn't say either of those things. What I said was that this amendment was amounted to what's called the trap statute or a trap amendment throughout the country that have been deemed unconstitutional. The way this is written is it's designed to put additional onus upon medical facilities, which would ultimately not make them eligible or able to perform abortions, and that the statutes have been ruled unconstitutional.
And again, Mr. President, if I may, so just to get an answer, I'm not sure if anyone here in the room can answer the question. Do we inspect these clinics? Does the health department inspect these clinics on a yearly basis, just like we do a McDonald's, maybe even a animal hospital? or other places that need to be inspected? That's the answer I'm trying to find out. Do we do that now or not?
Senator Dela Cruz, we are still on the amendment.
Thank you, Mr. President. I'm just going to read an excerpt here from an article about the Kermit Gosnell case. After 1993, an oversight by Pennsylvania Department of Health came to an end due to pro-choice political pressure. As noted in the grand jury report, the Department of Health abruptly decided for political reasons to stop inspecting abortion clinics at all. The politics in question were not anti-abortion, but pro. Again, if this can happen in Pennsylvania where there's pressure because a pro-choice group says you can't enforce these standards because if you do, we're going to call you out as anti-woman or pro-life. This is not what the bill is trying to do, my amendment. I'm just trying to protect women. And here we go. I'm just going to show you these two from the Department of Health. Just 2 in 10 years. And one of them was only because they were moving locations. So it was mandated that they were inspected. So technically, 1 inspection was done in 10 years. 1 was because they moved a location. Safe for women.
Thank you, Senator Dela Cruz. Further discussion on the amendment? Hearing none, the clerk will unlock the machine. Those voting for the amendment, vote in the green. Those voting against the amendment, vote in the red. If all members have recorded their vote, the clerk will lock the machine. There are 13 votes in affirmative, 25 in the negative, and the amendment fails. Are there any other amendments to be offered at this point in time? Because I think there are some members that would like to speak on the act itself. Senator Morgan.
Thank you, Mr. President. Under existing Rhode Island law, the cost of abortions performed by Medicaid-eligible women may be paid by the state only if they qualify for reimbursement under the Hyde Amendment, which authorizes payment for abortion if the procedure is necessary to save the life of a woman or the pregnancy is resulted from rape or incest. Under controlling Supreme Court authority, the states have no constitutional obligation to pay for abortions for which federal reimbursement is not available. Yet H 5125 substitute B does not expressly preserve this restriction of public funding for abortions. This likely invalidating Rhode Island's rule restricting public funding of abortions to those abortions for which partial reimbursement is available under the Hyde Amendment, the life of the mother, rape or incest. So I am asking you, Mr. President, to move LC 000518/41, which would, by inserting the language Rhode Island Medicaid rules 0.300.20.05 N130500200 for rape or incest, and then the life of the mother after the language requirements. So we are not required by taxpayers to pay this unless the life of the mother is in jeopardy, it is a rape or an incest. So this basically says we will not pay for the funding. Taxpayers will not fund this. Thank you, Mr. President.
Senator Morgan offers LC 000518/41. Is there a second? Seconded by Senator Dela Cruz. Discussion on the amendment. Senator Metz, would you like to discuss the amendment? Senator Sheehan on the amendment. Senator Lynch Prata.
Thank you, Mr. President. I rise in opposition to this amendment. The bill states very clearly on page 9, line 24 through 27, that abortion coverage under Medicaid is prohibited, quote, except to prevent the death of the mother in cases of rape or incest or to save the life of the pregnant individual, close quote. And I urge all my colleagues to vote against this amendment.
Senator Morgan, on the amendment.
Mr. President, on page 2, line 14, by deleting the word "or," and page 2, line 15, by inserting the language Rhode Island Medicare rules, and they have the number of the rules, and life of the mother, after the language requirements.
Senator Morgan, I believe that you have moved that, and it has been seconded by Senator Dela Cruz. Discussion on the amendment. Senator Crowley.
Amendment, President, but may I be voted for in the affirmative on the First Amendment that dealt with infancy and anesthesia?
Did you vote on that before, Senator?
I did. I voted no, but
You voted no? You would
yeah,
like to
I would like to change
your vote
it to yes.
on the First Amendment from a no to a yes?
Yes.
It does not affect the outcome. Hearing no objection, so ordered. We are on the amendment. On the amendment. The clerk will unlock the machine. Have all members recorded their vote on the amendment? The clerk will lock the machine. There are 11 votes in the affirmative, 27 in the negative, and the amendment fails. Are there other amendments to be offered? We are on the act. Senator Morgan, do you have an amendment that you want to offer?
Mr. President, I hereby move to amend H 5125, substitute B, entitled Act Relating to Health and Safety. On page 12, it's Amendment LC 000518/35. This is basically the trigger. As we said, Roe versus Wade is safe. There is no, it's not going to be reversed tomorrow. It's not going to be reversed the next week. And having President Trump in office doesn't mean that the Supreme Court will reverse Roe versus Wade. It's just not going to happen. And for us to have the dilemma of, oh, we have to do it now, it's just not feasible. So we are asking for a trigger for it to take effect upon the reversal of Roe versus Wade. Thank you.
Senator Morgan offers the amendment LC 000518/35. Is there a second? Seconded by Senator Dela Cruz. Discussion on the amendment. Chairwoman Lynch Prata.
Thank you, Mr. President. I rise in opposition to this so-called trigger amendment. The short, I guess, version would be that it's almost impossible to determine what reversing or overruling the Roe versus Wade would entail. I would start by saying it's not just Roe versus Wade that encompasses the current status quo. It's case law that follows Roe versus Wade. Anybody who reads any Supreme Court decisions would know that most often a decision is overturned in part or upheld in part. We'd have a significant issue and concern determining when that trigger would come into play and when that trigger would take effect. I would suggest to this body that it has been over 45 years since Roe versus Wade has been decided. It has taken us that long to come up with a statute codifying what it says. I, quite frankly, am not willing to wait another 45 years to determine what that trigger is, and I encourage all of my colleagues to vote against it.
Thank you, Madam Chair. Senator Connolly, we are on the amendment.
Thank you, Mr. President. While many of the amendments before this one have been directed to substantive issues in the bill, which have been well vetted over hours of testimony by the committee and by the committee chair, this bill really is directed to the heart of our legislative function. We are the elected lawmakers in Rhode Island. We determine what public policies and values are enacted into Rhode Island laws. We should jealously guard our policy-making authority and legislative responsibility. We should not surrender that authority to another branch of government. It's not our function, and we don't interpret the Constitution or judicial opinions. It's well settled that's the task of the courts. Judicial decisions are refined over time based on the doctrine of stare decisis and the well-accepted canons of statutory construction, which obligate courts to follow the decisions of previous cases when presented with similar facts and issues. A legislature is not designed or well-suited to interpreting whether future judicial language refines, reverses, modifies, overturns, all of which are discreetly different in the eyes of the law, a prior judicial decision. This amendment reverses our well-established Republican principle that legislators determine policy through the enactment of laws, and the judicial branch of government interprets those laws as applied to specific facts which come before the court. Today, we are determining the policy that should be embodied in Rhode Island law. We should not abdicate this solemn obligation to some indeterminate time in the future and some undetermined judicial construct in the future. We are the ones who are accountable to the citizens in Rhode Island. Regardless whether you support this bill or whether you oppose it, today especially, you should not shirk your responsibility based on some far-fetched notion that some issue related to this might be decided at some indeterminate point in time based on an unknown set of facts and statutes far beyond Rhode Island and the people we represent. I urge all of my colleagues, even those who oppose the bill, to oppose this amendment and stand up for legislative responsibility and accountability. Vote this amendment down, please. Thank you, Mr. President.
Thank you, Chairman Connolly. We are on the amendment. Senator Sheehan.
Thank you, Mr. President. I'd just like to address the issue of the likelihood that Roe might be tampered with or in some way be adjusted or overturned. I would have to start by saying that then candidate Donald Trump had professed in a debate format on national TV that he pledged to appoint pro-life justices that, by virtue of them being on the court, would eventually overturn Roe v. Wade or send it back to the states, to be precise. Since then, we saw the former President Barack Obama nominate, according to the Constitution, a gentleman named Merrick Garland, a quite esteemed judge, who was not acted upon by the U.S. Senate. So that would have been someone who perhaps may have been more left-leaning, left of center in terms of his philosophy. But instead of that, what we got was a man named Neil Gorsuch. When President Trump came in and nominated Mr. Gorsuch, he was given advice consent through the U.S. Senate. He replaced Antonin Scalia, and decidedly he was a conservative. Since then, we've seen another justice retire, Anthony Kennedy, and we saw Mr. Brett Kavanaugh advance through quite contentious advice consent hearings in the U.S. Senate, and he was eventually sworn in as a Supreme Court justice. My math just tells me that that is not perhaps unlikely, but perhaps possible, that this decision of Roe v. Wade and its progeny could be tampered with, overturned, or in some way changed. There was a recent Supreme Court decision out there that I was just reading about this morning, Mr. President, which said that Clarence Thomas, Supreme Court Justice, who wrote a majority opinion in this particular case, was looking at perhaps changing stare decisis, which is court precedent, in terms of what he considered one of the biggest mistakes of the court, which was the Roe decision, which he found erroneous. Since then, of course, we've seen, not to be outdone, 2 state legislatures, in contravention to their oath to uphold and defend the Constitution, vote to pass laws that contradicted the interpretation of the Constitution by the United States Supreme Court in '73 and beyond. So therefore, all I'm submitting for consideration is, can it happen? Certainly, I think so. And until it happens, this law before us today will not be the controlling or guiding authority on this issue of abortion, but it will remain the Supreme Court's decisions. Thank you, Mr. President.
Thank you, Senator Sheehan. Further discussion on the amendment? Senator Morgan.
Thank you, Mr. President. In 1986, we had a constitutional convention. And apparently, Article 1, Section 2 of that Constitutional Convention declaration was about abortion, and it was voted on by the people. It was voted on for funding, and I think by law, restricted. So this bill, I think, is going beyond that law, and we really need to look at that Constitutional Convention and maybe take a vote of the people who would be voting for or against this so-called codification of Roe versus Wade.
Thank you, Senator Morgan. Further discussion on the amendment? Chairwoman Lynch Prata.
Thank you, Mr. President. I just want to point out that the Rhode Island Constitution in no way prohibits the legislature's ability to establish legislation relative to abortion in the state of Rhode Island.
Thank you, Senator Lynch Prata. Further discussion on the amendment? Hearing none, the clerk will please. Senator De La Cruz, you've already spoken twice on this amendment. Senator, if someone would like, no? Oh. I stand corrected.
Thank you, Mr. President. All right. Very quickly, Roberts is not the conservative darling everyone thought he would be. It has been well noted that Justice Roberts has a history, along with the court's handlings of abortion cases in recent years, which suggests he will not move to overturn the right of an abortion soon or all at once, or is particularly unlikely to do so in the next year or 2. Or 3, or 4, or 5. This is fear-mongering. This is, oh my God, Roe's going to be overturned. There's nothing in the docket at the Supreme Court. Nothing's being presented just yet about overturning Roe. If there is, as Senator Raptakis has said so many times on television and on the radio, we are here every 6 months. If something like that were to come up, we could address it. But there is no imminent danger to Roe versus Wade.
Thank you, Senator De La Cruz. Further discussion on the amendment? Hearing none on the amendment, the clerk will please unlock the machine. If all members have recorded their vote, the clerk will lock the machine. There were 13 votes in favor, 25 against. The amendment fails. Are there any other amendments to offer? Senator Crowley, you have an amendment?
No, Mr. President.
Are we on the act? Senator Crowley.
Mr. President, members of the Senate, this has been a real tough day or week for me. But I believe this legislation has been thoroughly vetted with hours of testimony in both chambers for and against this bill. The time has come for us to weigh in on the issue. Like most of you, I have participated in hours of phone calls, countless emails, and many general conversations on abortion. I voted this bill out of committee because I felt it was the right thing for me to do. To keep it in committee only delays for another year this very important issue. We need to deal with this bill so that we can move on to other important issues facing our state. We are the people Where are the people who are out there right now hollering and screaming on issues like child abuse, homelessness, the opioid crisis, developmental issues, medical health issues, drunk driving, death resulting issues, domestic violence, just to name a few. And I think we could go on and on and on. Make no mistake about this. I repeat, make no mistake about this. I am pro-life and believe in the sanctity of God-given life. I listened to many doctors who gave me personal phone calls telling me of the horrors that women face and go through when they are faced with an unwanted pregnancy for personal home issues that are going on. And I sympathize and feel very heartbroken that they are facing this. I have also heard from those who were supposed to have been aborted, but their mother made the choice to keep them. A very wise woman, when addressing a group of people who had awarded her the Nobel Peace Prize and worked tirelessly for the poor, said on abortion, "If you don't want them, give them to me." She worked among the poorest of the poor, and yet she still advised that women have their babies and God would take care of them. I need not say who this woman was. I will be voting no on this bill because I believe in life. And I think of the hundreds of couples who cannot have a baby and want very much to be parents. Pregnancy is a blessing, and no matter what life throws at you, and I know, I have personal reasons to know, that the one thing that made me very happy was to be a mother. Thank you, Mr. President.
Thank you, Senator Crowley. I want to remind my colleagues that you have 5 minutes on the floor on the bill itself, but you can rise again if you haven't spoken previously, so please keep that in mind. Senator Metz.
Thank you, Mr. President, and ladies and gentlemen of the Senate. I appreciate the opportunity to share my perspective on this issue, and I'm going to do so with love and civility. But I'm in opposition to H5125 sub B. First, let me say that, you know, I'm a deacon, and God is immutable, and he does not change according to Scripture. He's the same yesterday, today, and tomorrow. And God, he has a standard for holiness. And as we study the end times, eschatology, the second coming of Christ, in Matthew 24 and 2 Timothy 3, it reveals that in the end times there's going to be deceivers, wars, rumors of wars, nation against nation, famines, pestilence, earthquakes, sorrows, perilous times. Men will be lovers of themselves, unthankful, unholy, fierce, despisers of those that are good, traitors, high-minded, lovers of pleasure more than lovers of God. And doesn't that sound like our current times? In my 29 years of serving this General Assembly, 14 in the House and now 15 in the Senate, the night the bill went down in Judiciary 5-4 was the first time in 29 years that I had to be escorted to the elevator by a state policeman. Unbelievable. And the young lady that was yelling and cussing me out, making veiled threats, I had to alert our church security and the Providence Police at our worship service. She didn't show up, and if she did, she was welcome to worship with us. We would have prayed for her, but I've never seen anything like it, and my church never took a vote on this issue, and I suspect that there's people on both sides of the issue as members. I'm amazed that so much negative energy was spent on something that's already law, and frankly speaking, there are many issues more important to my constituents. So personally, I'm more concerned for the salvation of others, the second coming of Christ, rather than being overly concerned with fear about what the President and Supreme Court might do. I understand that this is a heart-wrenching issue, But for me, it's not about imposing biblical morality on others, but advancing social good. I do have to wonder if we're seeing the fulfillment of Isaiah's prophecy in chapter 5, verse 20, the days when evil is called good and good is called evil, putting darkness for light and light for darkness. Sin is sin, no matter how the language is sanitized, and God loves the sinner, but he hates the sin. Make no mistake about it, this is a biblical, ethical, and spiritual issue confronting us all. Genesis 1, verse 27 is clear. We are all made in God's image, and, quote, to keep a baby from being born is to rob God of the glory he deserves from that child. Abortion robs God of his glory by substituting man and government in God's place to determine life and death. And that's from Russell Moore and Andrew T. Walker, The Gospel and Abortion. And let me remind those who want my views silenced of my constitutional First Amendment right to religious liberty. And I was confronted in committee. They had their view, their religious views, and I have mine. This is America. They're entitled to theirs, and I'm entitled to mine. And this reminds me of when they tried to silence Peter and John from speaking the gospel, and Peter and John responded, "It's better for us to please God than man." And I feel the same way. Moreover, the separation of the church and state means that we separate the institutions, but not the biblical influence. The founding fathers quoted scripture in their speeches, and one example is President George Washington, who said, and I quote, "It is impossible to govern rightly without God and the Bible." God is the creator, and the creation is supposed to worship the creator, not the reverse. Again, we are created in God's image. The question then is, who favors abortion more, God or Satan? Does your heart break for the things that break the heart of God, according to Pastor Mark Batterson? Again, creation is to worship the Creator who gave it life. The birth of children is celebrated in the Bible. Again, Genesis 1:26 and 27 states that we are made in God's image. In Jeremiah chapter 1, verse 5, it mentioned that he was told by God that he knew him before he was in his mother's womb, and his purpose was to become a prophet. And then Psalm 139, 13 and 14 said, and I quote, "For thou hast possessed my reins, thou hast covered me in my mother's womb. I will praise thee, for I am fearfully and wonderfully made. Marvelous are thy works, that thy soul knoweth right well." Every breath we take, the entire creation, it all belongs to God. From conception throughout our adult lives, we're created to give glory to God and fulfill his purpose for our lives.
Senator Metz, if you could finish up, please.
I'm on the last part of it, please. It's so disheartening. Where was the love the weeks leading up to this debate? The two greatest commandments cited in Mark chapter 12 is the one to love God with our whole heart, mind, and soul, and to love our neighbor as we love ourselves. Where is it? So who's my neighbor? Pro-choice advocates are my neighbor. Pro-life advocates are my neighbor. Adults, mothers and fathers from all backgrounds are my neighbor. And children conceived and made in God's image are my neighbor. So be not deceived. God is not mocked. Whatsoever a man soweth, that shall he also reap. For he that soweth to his flesh shall of the flesh reap corruption, but he that soweth to the Spirit shall of the Spirit reap life everlasting. Galatians 6, 7, and 8. In closing, to keep a baby from being born is to rob God of the glory he deserves from that child. Abortion robs God of his glory by substituting man and government in God's place to determine life and death. Where is the love in that? So based on biblical principles given to us by the Creator, I will be voting in opposition to this ungodly abortion bill. Thank you for listening.
Thank you, Senator Metz. Senator Valverde.
Thank you, Mr. President. I rise in support of this bill. Relatively recently, I carried 2 pregnancies to term and gave birth to 2 sons. I was fortunate that both were healthy, by-the-book pregnancies, and I had no major complications giving birth. I was really lucky. But even in the best of circumstances, when the pregnant person is in great health, as I was, when the fetus is developing normally, when the medical, financial, and emotional needs of both are met, pregnancy and birth are inherently risky, and speaking from experience, can be quite scary. Despite the beauty, birth can be a traumatic experience. It changes you in ways that the majority of the members in this chamber today will never truly understand. I have always supported the right of all people to make their own reproductive health care choices, but being pregnant and giving birth have only made me more pro-choice, made me more absolutely sure that no one should ever be forced to give birth against their will. I stand today firmly in support of this legislation, and I thank my colleagues who have been fighting for this for years, especially Senator Golden, Senator Sosnowski, Senator Coyne, Senator Lynch Prata, Senator Miller, and of course those that came before them. I am proud to join them tonight. And I thank the tireless advocates who never gave up hope. I will vote yes today because abortion is health care, and no one should have to live with the fear that their health care decisions will be made by anyone other than themselves. Thank you.
Thank you, Senator Valverde. Senator Sosnowski.
Thank you, Mr. President. Ladies and gentlemen of the Senate, I rise to second this bill, and I'd like to thank all the senators who have worked so hard to bring this bill to the floor today, especially you, Mr. President. But Chairwoman Lynch Prata, the hours of hard work is so appreciated. Chairman Miller, Senators Golden, Senators Archambault, and Senator Oyer. In the past, there were not as many senators who were supportive of women's reproductive freedom in this chamber. But there were some, including myself, who during the past 2 decades have been solidly pro-choice, and we bravely sponsored and co-sponsored favorable legislation, and we would bravely oppose bills that came to the Senate floor that would infringe upon women's reproductive freedom. Today, I would like to acknowledge some former senators that I had the privilege to serve with and show my gratitude for their leadership and tireless efforts to forge the path that has led us to where we are today. Of course, one pro-choice senator who always has been a strong leader for women's rights is the former Senator Honorable Rhoda Perry. And I would be remiss if I didn't acknowledge the late Honorable June Gibbs and the late Honorable David Bates for their courageous, steadfast support for a woman's right to choose. They were both amazing senators, and yes, they were both Republicans. We have all received numerous emails, letters, postcards, and phone calls for and against this issue, most very passionate, some threatening, always informative. I received an email, and if I may, I just want to take a few excerpts. It was very thought-provoking. Dear Senator Sosnowski, please think long and deeply about your commitment to the women of Rhode Island before the vote on the Reproductive Privacy Act that's coming before the Rhode Island Senate on Wednesday. We all know that women of means, and mostly whiteness, will always be able to terminate a pregnancy if they feel it is necessary for their health and safety. It is women in poverty, young and very young women, women of color, women who are aware that they are unable to care for the children they already have, let alone another one. Women who've been raped by family members or brutally raped by strangers are women who need your help. For them, the ability to terminate a pregnancy with safety and decency and compassion is often a lifesaver. And this person says, I know from that experience. And very informative in this email, let's consider this issue in the voice of the U.S. Constitution. Amendment 1 Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. And she says, no, it does not use the word separation of church and state. But the Supreme Court clearly established in Everson versus Board of Education that clause was intended to erect a wall of separation between church and state. And the United States is not a theocracy, nor is the state of Rhode Island. And she goes on to refer to Amendment 13 in the U.S. Constitution, Section 1. Neither slavery nor involuntary servitude, except as punishment for a convicted crime, shall exist within the United States. And she goes on to explain the word slavery, as used in the Constitution, means the ownership of another human being, absolute control over his or her body and mind. And none of us own one another. Your body and your mind is yours to care for as you see fit, and my body and mind are mine to care for as I see fit. And no one owns your body, no one owns my body. Each of us has the right to choose what to do with and how we care for our bodies. So you can see that was a pretty powerful email. And in closing today, on June 19th, 2019, I will proudly vote for this bill that will codify Roe v. Wade, as Chair Prata said, put into law the current status quo. It will protect women's reproductive health care in Rhode Island, and I hope my Senate colleagues will join me and also vote for this measure today. Thank you, Mr. President.
Thank you, Madam Chair. Senator Chacon.
Thank you, Mr. President. Let me begin by saying everyone in this chamber represents a district, and I respect everyone in here and the districts that they represent. So most naturally, everyone has a various opinion on different legislation that comes before it. But there's always been one thing in all my years up here, no matter what the issue was, whether we were divided, whether we fought, and most people do not see us argue on television because we do it in the back rooms here, and we usually resolve our differences, and after a vote is taken, we all get back together and we move forward. When it comes to emails, I don't really look at emails that do not come from my district. But I will say this. On this issue, I had 2 emails from my district that were in favor of pro-life. The majority of emails that I received were for me to vote in opposition of this bill. All of them believed in Roe versus Wade, but they did not accept what's taking place in this bill. So based on the constituency that I represent and the district that I represent, I will be voting no on this issue. Thank you.
Thank you, Senator Chacon. Senator Golden.
Thank you. It will come to no surprise that I'm rising in support of this bill. While the inauguration of President Trump set much of this bill's activism into motion, it was last fall during the Kavanaugh confirmation process when women across this country saw what was really at stake. Over the course of this legislative session, I have thought frequently about a New York Times op-ed that was written at the time by Rebecca Traister, in which she describes women's reactions to the Kavanaugh hearings. And I quote, "Most of the time, female anger is discouraged, repressed, ignored, swallowed, or transformed into something more palatable and less recognizable as fury, something like tears. When women are truly livid, they often weep. Maybe we cry when we're furious in part because we feel a kind of grief of all the things we want to say or yell that we know we can't. Maybe we're just sad about the very same things we're angry about." My advocacy for reproductive rights and this bill is grounded in my own experience as a woman, as an adoptive parent, and as a member of a religious minority in this country. Judaism recognizes that denying a woman full access to the complete spectrum of reproductive health care, including contraception and abortion, deprives women of their constitutional right to religious freedom. The Reproductive Privacy Act is not only about a constitutional right to privacy, it is also the right to practice my religion without the interference of the government. This bill also acknowledges that women have the moral agency to make their own decisions, including when and whether to become a parent. While this bill maintains the current status quo on access to abortion, the passage of this legislation is about far more than the law it will create. It is about showing that Rhode Island finally recognizes a pregnant person's right to make her own healthcare decisions. The Reproductive Privacy Act is 46 years in the making, and I'd like to thank the generations who advocated before me, including women who are elected to office, some of whom are in this room. I'm deeply grateful to Senator Lynch Prata for her unwavering commitment to seeing this moment come to fruition and getting this bill to the floor. And I am very thankful for the Senate President, whose leadership made today's vote possible. Every co-sponsor of the Senate bill who spent the past 6 months talking with doctors and lawyers and religious leaders, their constituents, and our colleagues deserves recognition. And I also want to recognize the considerable amount of time spent by my colleagues in the Judiciary Committee. To each and every person who shed tears of fury and stood by me while I shed mine, I want to say we got here tonight to this vote together. Mostly, I'd like to acknowledge the thousands of Rhode Islanders who spoke out in support of this bill, women and men from young teenagers who fearlessly came up to this building and protested, to women decades older than me who did not think they'd be fighting this battle once again in 2019. Tonight's vote is a clear message. Your voices have been heard.
Thank you, Senator Golden. Senator Cano.
Thank you, Mr. President, members of the chamber. Today I'm voting yes for a compromise bill codified in Roe versus Wade in Rhode Island. This is a very passionate issue that many people struggle with, emotionally, morally, ethically. I was raised Catholic and pro-life. Religion is an important part of my life, and my faith is very important to me. I believe that life is sacred, and I believe that faith is our personal relationship with God. However, I also believe that Roe versus Wade is the law of the land, and I can impose my faith on others through the legislation process. We can and should reduce the number of abortions. We need to be doing a better job of talking to our young people about contraception and health care and choices that are available, such as adoption. I also believe that we should be doing everything we can to reduce the number of unwanted pregnancies and teenager pregnancies. Babies, children, and the innocents have been at the center of this debate, including my own baby on my womb. I have been very judged, which, by the way, that is not a secret that I'm currently living the most beautiful experience being pregnant with a baby girl, but this experience wasn't easy at the beginning, and quite honest, very scary, going through a series of genetic testing and counseling. But I was grateful to be able to keep my faith and also to have options that every woman deserves to have. Wherever you are on the issue, or whenever you are on this issue, let's agree to stand together and protect our youngest that are in care of the CYF, who need our help. Our youngest who don't have parents, who also need our help. Our youngest who have been separated in cages at the border, who need our help. And our youngest who are suffering from war, famine, or poverty, who need our help. Together, we can lift all of our children and families out of poverty, out of suffering, and out of desperation, and towards a greater good for all. I'm voting yes, and I urge my colleagues to do the same, and thank you for letting me share my experience.
Thank you, Senator Cano. Senator Lombardo.
Thank you, Mr. President, members of the Senate. I come to you today not only as your colleague, but also as a servant to God. We are all children of God. And I tell you, we will all be accountable to God for the position of influence that He has given to all of us. We will be judged today on the decision that we make. I pray you do what's right, not because you have given your word or made a promise to an organization, not because people are telling you it should be a woman's right to choose, not because you do not want to deal with the bullying that has been going on since January. Do it because you will be judged on the single most important issue in your life. We know God is a loving God and a forgiving God, but the Bible teaches us that we should live our life in the image of God. We will all someday meet our Maker, our God in heaven. And when He looks into your eyes and deep into your soul, and He says, whatever you have done to the least of your brethren, you have done unto me. And there will be no explanation needed. Before you serve any man or woman, you need to serve God first. I ask you be responsible men and women who live their lives for what matters in eternity. Thank you, Mr. President.
Thank you, Chairman Lombardo. Senator Nesselbush.
Thank you, Mr. President, ladies and gentlemen of the Senate. I rise on this historic occasion to thank the so many who have worked so long and so hard to get us to this historic and important moment. I thank Senator Sosnowski for sharing with us all of the work of the senators who came before us. And I want to thank the advocates who throughout this session seemed like there were thousands of pink shirts in this building wanting to have their voices heard. Now, I regret in our Senate any time when there is division among us, but I'm so proud of the work that our Senate did on this bill. I want to thank our leadership team for getting us to this moment. I thank Senator Golden for her leadership on the Senate version of the bill and on this bill as it moved forward. And of course, I applaud Senator Lynch Prata, who has my utmost respect for her unwavering commitment and that she somehow ended up being the Senator Archambault whisperer. And I also thank Senator Archambault for coming back to the table day in and day out and somehow getting us to this moment where we are codifying Roe versus Wade. It's important to know, as I know this is a divisive issue, that we are neither increasing or decreasing the rights that exist under law. We are simply codifying them, putting them in one place, and removing various unconstitutional provisions that somehow still existed in our laws years after they were found unconstitutional by our Supreme Court. I understand that there are different views on this issue, and I respect that. But as I said in committee, if your religious views or your conscience doesn't support abortion, and I don't mean to be smug about this, but then don't have one. With Trump in office and with his picks for the United States Supreme Court, women are understandably scared. And I'm glad we are answering the call of the people, the call of the women, to safeguard our right to a safe and legal abortion. I hope that all of those who have been coming up here in the blue shirts on behalf of the unborn will care as much about the born children of this nation and of this state, and will work hard on the child sexual abuse statute of limitations reform bills that are working their ways through the General Assembly, because those are real live children who are now adults who have been victimized and can use their support. I have been pro-choice since the time I understood what the issue meant. And I'm joined here in the gallery today by two friends who I've known since college. And when we were in college together, we would often gather on Saturday mornings and we would escort women who found themselves in trouble. They were scared. Many times they were poor and had no money. And we would escort them into a healthcare clinic to get an abortion. Why did we escort them? Because they were so heckled and harassed when they were simply trying to enter a clinic to get reproductive health care. I am pleased that we are enacting a law that trusts and allows women to take control of our own bodies and to make decisions about our own bodies, and that provides all women with the reproductive freedom that we deserve. I enthusiastically support this bill.
Thank you, Senator Nestor-Bush. Senator Murray.
Thank you, Mr. President. Senate colleagues, I rise in full support of the Reproductive Privacy Act, and I want to thank all of my colleagues who have worked tirelessly to bring this bill to the floor. Thank you. I also want to acknowledge and thank the many legislators who have come before us who fought for reproductive freedom, many of them for decades. In fact, my own family has a long history in the fight for reproductive rights. My father was a representative and became a state senator back in 1974. He was unapologetically pro-choice, and whenever bills regarding choice were on the floor, he always voted for the rights of women to, as he stated, determine their own health and decisions and futures. I stand here today at the very same desk, 45 years later, to urge my Senate colleagues to preserve and protect reproductive freedom for all women by codifying Roe and its progeny into Rhode Island state law. I have always believed that all individuals have a right to bodily autonomy, that a woman should always have control and say over when and if she wants to start a family, and the freedom to choose how many children she wishes to have. But my reason for supporting this bill is very simple. I trust women. Trust them to manage their own health, to make their own decisions, to plan their families and their futures, and to do what is best for them in their own individual circumstances. I urge all of you to stand with me in that trust and support this bill. Thank you.
Thank you, Senator Murray. Senator Miller.
Yes, I believe what we need to do today is to trust women. That this legislation assures that a woman's guidance is from their Bible, their church, synagogue, mosque, from the words of their ancestors or poetry, not ours, not yours. That women have the right to seek the advice of a doctor for medical decisions and assistance without our interference. We need to trust that the women who helped craft this legislation, with maybe a little help from a few men, got this right. That the words in this bill, guided by the years of works of those before them, and the many who came forward during hours of hearings, that the work of Senators Golden, Lynch Prata, Oyer, Coyne, Sosnowski, Reps. Williams, and Agello assures that the law properly protects a woman's right to choose, guided by her beliefs and her doctors, not yours and not mine. I second this bill and plan to vote in favor.
Thank you, Chairman Miller. The Chairwoman Gallo.
Thank you, Mr. President. Colleagues, as most of you know, I have always been pro-life. This was a very, very hard decision for me, and I want to thank Chairwoman Lynch Prata for all of her help. It's unfortunate that everybody didn't feel like they could go to see her, because she definitely helped me, and when I told her I could not support the bill the way it was previously, she let me work with her, and she guided me with all her legal counsel and helped to make the bill acceptable for me. It's unfortunate that we've had all this bullying that has happened I spent the day responding to emails today, and it's unfortunate that it has to come to people threatening you. I'm going to do what I think is right, and I firmly believe what I'm doing is the right thing. If everybody here is pro-life, and that's what we're really talking about, the life, it's not just in uterus, it's when they come out. There are all these poor, desperate children with unfortunate lives that good Christian people ignore. They're not doing anything about it. I had the unfortunate, or maybe it was meant to be, experience of being, as everybody knows, I work in a school. I was in the office, and there was a little boy, kindergartner, that had peed his pants. His foster mother did not know where the school was and would not come and pick him up. That is horrendous and not acceptable. DCYF had to be called to come and bring him dry pants and tell her where the school was, which she waited an hour after school was closed from in the morning to come to get this little boy, which only God only knows what she did to him when she got him in her house. We need to do more and a better job at being foster parents, encouraging everybody to be foster parents. If you can adopt, certainly adopt. And not just one, a whole, like all the siblings, keep them together. If you clearly care about life and you're pro-life, let this be a reason today that we move forward and we make Rhode Island a better place for all children. And not just in uterus. Let's do it for everyone, every single one of the children that are in these horrible lives. Let's make it better for them. And I will be voting for this today. Thank you.
Thank you, Chairwoman Gallo. Senator Aptakis.
Thank you, Mr. President, ladies and gentlemen of the Senate. Last November, when I ran for this seat, I neither received the endorsement of pro-life or pro-choice. I was asked in one of the committees in one of the communities I represent, would I support legislation to codify Roe versus Wade if it was overturned? If it was overturned. And I said yes. But since then, like some of my colleagues had said earlier, a lot of bullying has taken place. My words were twisted and turned that you do not support the right for a woman to choose. We know what the results are in this state. In polls, 62% of Rhode Islanders approve the right for a woman to have an abortion. And 72% of Rhode Islanders reject partial birth abortion. We've had a lot of debate since January, and yet the one word that I think we did not achieve was compromise. Or else we would have been here, probably a shorter debate, probably very few amendments, and we would have moved forward to preserve in a compromised fashion 46 years of history since Roe versus Wade. I was disappointed I had a similar amendment that Senator Morgan had to make sure that if something happened in the Supreme Court, that this bill that's going to be voted on today would have been preserved. That would have been a compromise. Today, we learned one other new item, that inspection of clinics by the Rhode Island Health Department occurred, I believe, once or twice in 10 years. That's wrong. We inspect restaurants, we inspect animal hospitals, we inspect nail salons, beauty salons, and the list goes on and on. I think as we move forward, we should correct that. And I think this General Assembly has the right, anytime, to make this state a better place to live, whether you disagree or not agree with what's happening here this afternoon or the last 6 months. But basically, ladies and gentlemen, I hope that time will tell that the Supreme Court does not act, that Roe versus Wade does not get overturned, and hopefully that this bill was the right thing to do. Time will tell. But what I want to see when we vote today, that we break bread again amongst all of us, which is very important, to lead our state and make Rhode Island a better state. Thank you.
Thank you, Senator Raptakis. Senator Sheehan.
Thank you, Mr. President. My colleagues, during my tenure here in the state Senate, I haven't confronted an issue more contentious or divisive than the one before us today. It literally divides us as a community and as a body in part two. And I believe that's the case because there is passion, understated, passion and conviction on both sides of this abortion issue. Like the community at large, I guess in microcosm, I personally am divided or conflicted over this issue as well. It's been very difficult for me. I personally am troubled by the taking of any innocent human life in all of its stages. And I know that there are people on both sides of the issue who feel the same way. While there are a number of means to prevent pregnancy, however, I know that life is not neat. It's neither black nor white, but often is in the shades of gray. Unintended pregnancies do happen and lead to very difficult choices in life. Personally, if someone close to me were to have an unplanned pregnancy, I would encourage her to carry the baby to term, place it up for adoption, or I would support them even after the birth of the child. That's me. It's who I am. But here in front of you, I don't have the luxury to be just Jim Sheehan. Gentleman from North Kingstown, teacher, etc. I am a state senator. And I know that public policy cannot be based purely upon my own personal beliefs or viewpoints. Public policy must be informed by the views and sentiments of the community. It must also be carefully crafted based upon the facts, evidence, and the law. And the supreme law of the land, as everyone knows, is the United States Constitution. And the Supreme Court of the United States is rightfully empowered with the awesome responsibility and authority to interpret the meaning of the U.S. Constitution as well as how it applies to our ever-changing society. In regard to the landmark cases of Roe versus Wade, Doe versus Bolton, Planned Parenthood v. Casey, and others, taken together, the progeny, the U.S. Supreme Court's interpretation of the U.S. Constitution was that a woman has the right to choose to have an abortion up to the point of fetal viability, around 24 weeks. After fetal viability, the termination of a woman's pregnancy is expressly prohibited, as is stated in this statute before us for consideration, except when necessary in the medical judgment of a physician to preserve the life or health of the woman. This prohibition recognizes that the state does have an interest in the life of the unborn child after he or she has become viable. And I believe the compromise is contained in the language today that requires doctors to document that a late-term abortion was medically necessary to preserve the life or health of the mother with DOH oversight is a fine addition to that and answers many of the concerns that I had received from constituents. After lengthy research and rigorous analysis and a lot of reflection, Mr. President, members of the Senate, I decided that House Bill 5125 sub A is consistent with Supreme Court precedents regarding a woman's right to have an abortion in a manner that maintains the current status quo. As such, it is already the law of the land, including in our dear state, Rhode Island. Therefore, as a state legislator who has taken an oath to support and uphold the U.S. Constitution, I will vote today to codify into state law a woman's right to make her own reproductive decisions, as decided by the U.S. Supreme Court in Roe and its progeny. For these reasons, as I said, I'll be voting yes. And in conclusion, Mr. President, I believe that as a community we need to find common ground, not just on this issue, but many issues. And I would submit the common ground on this issue is to reduce the number of unwanted pregnancies in our state. Fewer unwanted pregnancies, fewer abortions by definition. And to do that, we need to expound upon sex ed, readily available contraception throughout the state, insured, covered, free as necessary, and also it is my sincere hope, not only through those means, but also through technological innovation, advances in medical science, that someday we will remove any need for abortion, and this debate today will just be a matter of history, important as it is. Thank you, Mr. President.
Thank you, Senator Sheehan. Senator Bell.
Thank you so much, Mr. President. I'm very proud to stand here and support this bill because I believe deeply that it is a woman's right to choose. But I also have to say how moved I've been throughout this whole debate, moved by the incredible stories I've heard from my constituents who reached out to me overwhelmingly to support this legislation, moved by the incredible and tireless hard work of so many advocates, by the hard work, leadership, and passion of so many in this room. And here I have to specifically commend Senator Golden for her vision, her leadership, and her perseverance. This bill is an important step, but I also have to agree strongly with everything that we've heard today about how our work does not end with this bill, and we have so many important issues to address for the condition of children in our state. So I'm very proud to be voting in favor of this legislation, and again, I cannot thank enough all the people in this room who worked so hard to make this happen.
Thank you, Senator Bell. Senator Morgan.
Thank you, Mr. President. I rise, obviously, in opposition to this bill. We are not trying to stop a woman's choice. We do trust women to make the right choice. As you heard testimony here on the amendments, it's not the women we don't trust. It's the facilities. Planned Parenthood does everything that they can. They're in the schools. They're giving out birth control. They're giving out condoms. They're giving out all kinds of ways not to get pregnant. When a woman gets pregnant, she should have a choice, and we're not saying she does not have a choice. What we're trying to convey is there are safety issues. There are problems with this bill. I don't know what deals have been made or cut for this bill to go through, but it's not a good bill. And Senator Gallo, you had mentioned foster care. I do foster care. I don't do it anymore, but I have done foster care. I've kept siblings together. I've had 2 boys from South Providence who I kept of color in my house for almost a year, brothers to keep together. So I do care about life, and I care about a woman's choice. But I want to see safe choices. And I want all of you, how could you not vote for a woman, for a baby to be ripped apart in the womb? That's hideous. What they do, these practices that Planned Parenthood does, and it's a hideous practice, to make a baby withstand an operation. I mean, they have a baby who, they go in and they do surgical procedures on pregnant women. They know that that baby feels pain. A baby had reached out. They have a picture of a woman that the doctor was doing the procedure on. The baby put out his hand and grabbed the doctor's finger. I mean, they feel pain. And I just cannot fathom that the people didn't vote for that, especially that Senator Dela Cruz had offered. No one is forced to give birth in the United States that I know of. I just, we don't have enough babies. We have to go out of the country to adopt a baby. And some of us here know that. We don't have enough babies in this state, in this country, because we're killing them all. And now we're allowing it to happen almost up until birth. Thank you. And I encourage my colleagues to vote against this.
Thank you, Senator Morgan. Whip Goodwin.
Mr. President, I rise just briefly. I'm not going to belabor the point, but I just wanted to point out, having sat through several hours of debate, and I heard some veiled comments from some of my colleagues, and I know everybody on this debate is well-meaning and they're sincere in their beliefs, and they think in their heart they're doing what's best for their constituency. I'm sure of that, because I know so many of you, and actually all of you personally. But I take kind of offense to some of the comments that I heard, that some of us in this chamber who are pro-life are not concerned about the poor, the unfortunate, the children that live amongst us now, because that's not the truth. I mean, we do here. As a matter of fact, the Women's Project, when they sent out their cards requesting in my district that I support this bill, they started the card by saying, let's thank Senator Goodwin for all the work she did in her long career for women, because I did. I voted for domestic violence, but I've sponsored them and passed into law so many domestic violence bills, helping to make the lives of women better. I have championed bills for children throughout my long career. I have done gun safety bills, you name it, Mr. President, for workers amongst us. I feel, Mr. President, that those kind of comments were not necessary. And for my part, many years ago, I came to this chamber pro-life, and today will be no different. I just wanted to point that out, that there are many, many of us on the pro-life side that do what we can here in this chamber to protect those who need us the most. Thank you, Mr. President.
Thank you, Madam Whip. Further discussion on the act. Senator Dela Cruz.
Thank you, Mr. President. This has been a long and difficult process, of one of which I have heard from hundreds of Rhode Islanders, not hundreds, close to a couple of thousand, I would say. But my constituency is a ratio of 15-1, as I said in committee, 15-1 against this legislation. They voiced their oppositions to these bills, and so I am representing their voice here today, as they elected me to do so. I'd also like to point out that multiple polls show that Rhode Islanders do not want us focusing our attention and time on these issues, specifically guns on the very bottom of the list and abortion just above it. They consistently poll near the bottom of the concerns Rhode Islanders have. They want us focusing on improving schools, better infrastructure, and improving our economy, of which we have failed. For the past 80 years, Rhode Island has been in decline. Also, this bill, a violation by a physician, carries only the possibility of some type of professional discipline, no criminal penalties. Professional discipline that isn't even mandated, but merely permitted. A crime without a punishment is unenforceable. Any of you that have children know, you can say, I'm going to punish you, I'm going to punish you, I'm going to punish you, but unless you do it, they're going to continue. A crime without a punishment is unenforceable. Also, back to the compromise that was cobbled together by a small working group. The Judiciary Committee should be the only small working group, as our purpose was to discuss, deliberate, and if needed, amend each bill that comes before us in an open and democratic manner. Having a small working group outside the committee that suddenly released an amendment the night before at 4 p.m. goes against the finest traditions of this body. The whole process was marred with controversy. I'm going to end with this. I'll close my comments tonight by recalling a similar struggle for the future of society. 200 years ago, British lawmakers were in a similar position. A few lawmakers were willing to challenge an established institution and practice, one that marginalized tens of thousands of fellow human beings. They were labeled as radicals and extremists because they recognized the sanctity of life in every human, no matter how different they were. We're talking about slavery. But tonight, I would like to end my remarks by quoting from the civil rights leader and abolitionist who tirelessly fought to end the great injustice of their time. As we are here today, the few pro-life senators, the great injustice of our time, as history will look back at us and say, where were you? As they look back at slavery and say, where were you? They will look back at us and say, you allowed for children to be ripped from limb to limb with no care, no concern for their literal feeling. William Wilberforce said, and I quote, "Let us not despair. It is a blessed cause, and success, though long, will crown our exertions. Already we have gained one victory. We have obtained for these poor creatures the recognition of their human nature, which, for a while, was most shamefully denied. This is the first fruits of our efforts. Let us persevere, and our triumph will be complete. Never, never will we desist until we have wiped away this scandal, released ourselves from the load of guilt which we at present labor, and extinguished every trace of this bloody traffic of which our posterity, looking back to the history of these enlightened times, will scarce believe that it had been suffered to exist so long, a disgrace and dishonor to this country." I hope that you remember those words as you vote. History will not look kindly on us.
Thank you, Senator Dela Cruz. Senator McKinney, for the first time.
Thank you, Mr. President, and thank you to you and the rest of the leadership, as well as particularly to Senator Lynch Prata for her efforts with respect to this bill. If we passed a law tomorrow to outlaw abortions in Rhode Island, they would not stop. They would simply become more dangerous. Legal or not, abortions will take place. The best way to prevent unwanted pregnancies, in my view, is with better access to education and to contraception, and persuading women not to have abortions. Those actions have in fact resulted in greatly reduced abortions in recent years. Personally, I am not in favor of abortion, but I've never found myself pregnant and never will. I ran for this office. It is a secular office. When I ran for it, I said that I would, in fact, support the status quo, and that is the protection of safe and legal and hopefully rare abortion, first established in Roe versus Wade. I don't know whether Roe versus Wade will be overturned, but I do know many people, women especially, were extremely fearful and concerned given the makeup of the Supreme Court and of the executive branch at the federal level. So in the face of a potentially contrary U.S. Supreme Court decision, I intend to maintain the status quo. I would not have voted for these bills as originally formulated. I did believe that they went too far. This reworked bill, though, in my opinion, is in line with the essential Roe principles. I did not support any amendments here today. And that's not because I believe that this bill is perfect. It's not. No bill is perfect. But I do understand that it is the product of considerable collaboration and indeed compromise. And I don't intend to disturb that. I don't agree that this is an expansion of the status quo. This bill ensures that women can have abortions legally and safely. And it provides safeguards against the concerns that many have, and that is with respect to post-viability abortions not being done for insubstantial reasons. I know others will view the passage of this bill as a victory. For me, it will not be a cause for celebration. But I understand why, for many people, women especially, this will be a milestone. For too long, the concerns of women have been given less attention than they deserve to have. I've received all the same threats of political opposition if I support this measure. I understand that. That's democracy in action. But I don't intend to be intimidated, and I intend to vote the way I believe I should vote.
and I will continue to work in the future to try to avoid and help prevent unwanted pregnancies and abortions, to promote alternatives, to improve access to education and contraception, and to adoption, to support women and their families. Thank you.
Thank you, Senator McKinney. Further discussion? Hearing none, the clerk will please unlock the machine. If all senators have recorded their vote, the clerk will lock the machine. There are 21 votes in the affirmative, 17 in the negative, and the act passes. Senator McCaffrey.
President, ladies and gentlemen of the Senate, can this act be transmitted to the House?
Senator McCaffrey requests that the act be transmitted to the House. Hearing no objection, so ordered. There is an objection. State your objection, Senator.
It wasn't properly vetted in judiciary, and it was properly vetted in judiciary. Sponsors were on that bill, and it needs to go back to judiciary.
Thank you, Senator. The chair has ruled that the bill can be transmitted. I'm going to ask the clerk to unlock the machine. Those who are for transmittal, please vote in the green. Those who are against transmittal, vote in the red. The clerk will lock the machine. There are 34 votes in the affirmative, 3 in the negative, and the act will be transmitted.